Welcome to S&C's podcast series, S&C Critical Insights. I'm Engebretson-Schooley, a partner in S&C's litigation group. Today, we're discussing an emerging and increasingly important development in stockholder derivative litigation, the rise of derivative claims under Section 10B of the Exchange Act. Joining me today are two of my partners in S&C's litigation group, Christopher Viapiano, who co-leads S&C's securities litigation group, and Lenny Traps. Christopher, Lenny, and I recently co-authored an article called The Rise and Eventual Fall, of derivative Section 10B claims, which was published by Bloomberg Law a couple weeks ago. So first, we'll give some background on these claims and why stockholder plaintiffs bring them, and then we'll turn to how they've evolved. We'll also discuss some of the logical inconsistencies in these claims that corporate defendants can highlight when faced with them. And finally, we'll suggest some strategies that corporate defendants and corporate counsel can consider to address the increasing prevalence of these claims, including the use of forum selection clauses. But before we get into strategies and the evolving landscape, Lenny, maybe you can give us a little background. What is a derivative Section 10B claim?
Happy to. Thanks, Ali. Traditionally, stockholder derivative lawsuits are grounded in state law, and they usually allege breaches of fiduciary duty. Derivative claims are internal claims, and they're governed by the law of the state where a corporation is incorporated. Most public companies adopt forum selection provisions requiring these derivative actions to be filed in state court, often in Delaware. But plaintiffs don't always want to be in Delaware. In recent years, we've seen these stockholder plaintiffs try to steer derivative litigation into federal court by tacking on federal securities claims under the Securities Exchange Act. And those claims can only be heard in federal court. That means that the state law derivative claims, that is, the typical breach of fiduciary duty claim, are asserted in a federal forum alongside federal securities claims. We've seen that plaintiffs prefer federal courts for a number of reasons. For one, plaintiffs sometimes view federal courts as more favorable forums over jurisdictions like Delaware State Court that they believe are traditionally less friendly to plaintiffs' claims. A more significant driver can be damages. By repackaging allegations around stock repurchases as federal securities violations, plaintiffs can assert large damages tied to the company's buybacks and seek much higher amounts than they traditionally have on breach of fiduciary duty claims. Finally, some of this is driven just by plaintiffs competing with one another for the same cases. A plaintiff may file in federal court, for example, to try to get ahead of a similar case already filed in Delaware, or to just get a seat at the table in any eventual settlement. For years, the go-to move was adding a Section 14A claim based on allegedly misleading statements in a corporation's proxy statement. That tactic, however, appears to be losing steam. In a case called Lee v. Fisher, the Ninth Circuit, sitting en banc, held that these Section 14A claims are actually direct claims, not derivative at all, meaning that they cannot be used as a jurisdictional hook to get derivative claims into federal court. If other circuits follow suit, or in the Ninth Circuit, plaintiffs would lose a major pathway into federal court, and that's where Section 10B comes in. In a classic direct Section 10B case, the theory is pretty straightforward. The company makes false or misleading statements that induces or maintains inflation in the stock price. Investors rely on the false statements to buy at inflated prices. The truth comes out, and investors suffer losses when the stock price declines. But derivative plaintiffs have adapted that theory now. Because many companies regularly adopt stock repurchase plans and repurchase their own stock, plaintiffs now argue that the company itself was harmed by the company's own false or misleading statements, because it bought back shares at an artificially inflated price. In our view, these claims suffer from both theoretical and practical problems, chief among them what we refer to in our article as a reliance paradox. And Christopher, maybe you can help us walk through that problem.
Absolutely. Thanks, Lenny. As Lenny noted, to succeed on a Section 10B claim, a plaintiff has to show that the plaintiff stockholder relied on the alleged misstatement when buying or selling stock. In a typical direct Section 10b claim, that's straightforward enough because the plaintiff is typically an investor who can establish a presumption of reliance on the corporation's allegedly false or misleading statements. But in a derivative suit, the plaintiff is pursuing claims on behalf of the corporation itself, effectively wresting control of the corporate claims from the corporation. So when the allegations are that a company made false statements through its directors, a derivative plaintiff must argue that the same company relied on those statements when approving stock repurchases. That theory first ran into trouble in a case called In re Verisign derivative litigation, a 2007 case from the Northern District of California. There, the court concluded that the derivative plaintiff could not establish the element of reliance in their Section 10b claims. The court put it pretty bluntly. If the directors made the false statements and the directors approved the repurchases, then the company, acting through those same directors, couldn't have been deceived. As another court later memorably phrased it, a story of deception needs two characters, the liar and the dupe. In a so-called derivative Section 10b claim, the liar and the dupe are the same.
In addition to VeriSign, in more recent years, district courts in Delaware have also highlighted this reliance paradox. Two cases, one is Elfers v. AbbVie and the other Franklin v. Sealed Air, both finding it, quote, factually impossible for directors to spread misinformation and then rely on it themselves. In other words, the company can't defraud itself. In both cases, for that reason, the district court dismissed the derivative Section 10b claims.
And that logic seems clear enough to me and to us, Ali, but not all courts have agreed with it. In the Countrywide case out of the Central District of California, for example, plaintiffs alleged that directors caused the company to issue misleading statements and repurchase stock, including from the directors themselves. That case had an element of self-dealing, and because of that, the court declined to impute the director's knowledge to the company. Similar reasoning we've seen in cases involving underpriced stock option grants, where directors allegedly benefit directly from the misconduct. Those cases are at least internally consistent. The theory is that directors acted for personal gain, not for the company's benefit, even though, in our view, they still suffer from the same fundamental reliance problem. But more recently, courts have gone even further in allowing these kinds of claims to proceed.
That's exactly right. Some courts have allowed derivative Section 10b claims that look exactly like ordinary securities fraud cases to proceed, without any allegations of self-dealing at all. And that expansion is troubling. It suggests that any direct Section 10b claim can be repackaged as a derivative claim so long as the company repurchased its stock.
And we haven't seen signs of these cases losing steam, although we, unfortunately, are seeing that courts are not really grappling with the reliance paradox at the bottom of these cases. We think that at the motion to dismiss stage, defendants should continue pressing the VeriSign line of cases, emphasizing that in the context of repurchases, plaintiffs cannot establish reliance as a simple matter of logic where the same defendants both make the statements and authorize the repurchases.
And even where self-dealing is alleged, these claims are often better understood as state law fiduciary duty claims, not federal securities fraud claims. Stockholders have long brought similar actions as state law claims in the context of breaches of fiduciary duties. For example, by alleging that director approval of backdated stock options violated the duties of care and loyalty. These claims avoid the reliance issues presented by Section 10b claims in this context without the logical contradictions baked into derivative Section 10b theories. Derivative plaintiffs aren't forced to allege that a company defrauded itself, and state law already provides a well-developed framework for addressing these issues.
Some of our listeners are likely familiar with what's been termed Dexit, the growing trend of companies moving out of Delaware and choosing to reincorporate in other states like Texas or Nevada. And those states seem to be at least indirectly trying to solicit companies away from Delaware. Does Dexit factor into this trend of derivative 10b claims at all?
Possibly. Some of the Dexit discontent has arisen from the perception that some of the Delaware Court of Chancery's recent decisions on corporate law have been overly shareholder plaintiff friendly, including in the context of Caremark failure of oversight claims. So you could imagine a future where plaintiffs' counsel decide they prefer being in Delaware and don't need Section 10B claims to get into federal court. But we clearly aren't there given the growing trend we've seen. What will be more interesting is whether, assuming the Dexit trend continues, the plaintiff side bar looks to rely more and more on federal Section 10B derivative claims if states like Texas or Nevada make state law derivative claims more difficult to bring.
That's interesting and definitely something to watch. Another issue I think we should explore here is, in addition to the reliance paradox and pushing that angle, there's potentially another important defense tool here, and that's forum selection clauses. Ali, can you give us the rundown on how corporate defendants can use those clauses to their advantage?
Sure. So, as we previewed, many Delaware companies require that derivative actions be brought in the Delaware Court of Chancery through forum selection clauses. Since claims brought under the Exchange Act can only be heard in federal court, if you have a forum selection clause saying all derivative claims have to be brought in Delaware state court, to enforce that clause, a court would have to dismiss the Exchange Act claims. And that's exactly what the Ninth Circuit did in Lee, dismissing Section 14A claims in order to enforce a forum selection clause.
Yes, and interestingly, that logic recently carried over to Section 10B claims, with at least one court dismissing a derivative Section 10B claim on forum nonconvenience grounds. Could you tell us about that case, Ali?
Sure. So that's Sobel v. Thompson. And in that case, a Texas federal court dismissed a derivative Section 10B claim to enforce a Delaware forum selection clause, reasoning that although enforcement of the provision would leave the derivative plaintiff with no forum for their Section 10B claims, the plaintiff still had meaningful remedies under state law, including by bringing disclosure-based claims as breach of fiduciary duty claims under Delaware law and Delaware Chancery Court.
Now, not every court has gone that way. Recently, in a case called In Re Block Inc. derivative litigation, for example, the district court found that the derivative action fell within the scope of the Exchange Act exception in the company's forum selection clause. As a result, the court never addressed arguments made by the defendants along the lines of the decision in Sobel that Ali described, that the forum selection provision could be enforced and the Exchange Act claims dismissed because plaintiff had adequate remedies in the Delaware Court of Chancery.
I think the bottom line here for defendants going forward is that Sobel offers a roadmap, even if not foolproof. Forum selection clauses can and should be enforced because they preserve a stockholder plaintiff's ability to seek relief while concentrating claims related to alleged breaches of fiduciary duty in a Delaware forum where those claims belong, because that forum is recognized for expertise in the field of state corporation law. As the court in Sobel explained, claims under Delaware law provide commensurate remedies to those available to plaintiffs under the federal securities laws.
Right. And enforcing these clauses also avoids the logical contradictions presented by derivative Section 10B claims that we've been discussing. Now, some of our listeners may also be familiar with the Seventh Circuit's decision in Seafarer's Pension Plan v. Bradway, and could be wondering, how does that fit into all of this?
Why don't I take that, Ali? For those unfamiliar, the Seventh Circuit in 2022 in Seafarer's Pension Plan found a forum selection clause to be unenforceable given the exclusive federal jurisdiction conferred in the Exchange Act over the plaintiff's Section 14A claims. In the wake of that decision, some corporations have taken steps to insulate their forum selection clauses, including carve-outs for federal Exchange Act claims. Given seafarers, there is risk that other courts will find forum selection clauses unenforceable absent a carve-out. While Sobel presents a possible strategy for corporate defendants, so far it's just one decision, and the case law is not that developed. In this landscape, companies may prefer a carve-out to making the Sobel-style argument?
I think we're just going to have to stay tuned and see if corporations' calculus evolves as Section 10b becomes a bigger problem. It's also entirely possible that more courts will disagree with the Seventh Circuit and align more closely with the Ninth Circuit's decision in Lee v. Fisher. The Sobel Court, for example, considered seafarers, but declined to adopt its reasoning.
So Lenny, Ollie, what's the bottom line here?
Well, I think first, defense attorneys should continue to argue that derivative Section 10b claims are fundamentally flawed because plaintiffs can't establish reliance. That's the reliance paradox we talked about, and you could see it in cases like VeriSign, Elfers, and Franklin. Defendants should also remind courts that these claims are better suited as breach of fiduciary duty claims, a framework that avoids those messy reliance issues altogether.
Agreed, Lenny. And then second, companies can adopt and leverage forum selection clauses, where those clauses limit the forum for derivative suits to Delaware Chancery Court. The Exchange Act's exclusive jurisdiction provision may require the dismissal of Section 10b claims. And these claims continue to be asserted by plaintiffs' lawyers. So companies and defense counsel, they have to be ready, both doctrinally and strategically.
Lenny, Ollie, thank you both. I think that's all the time we have for today. Thank you everyone for listening to S&C Critical Insights. You can find more information on derivative Section 10b suits in our recent article titled The Rise and Eventual Fall of Derivative Section 10b Claims. That article is dated January 21st, 2026, and was published with Bloomberg Law at www.bloomberglaw.com. For more information about our practice, please visit us on the web at sulcrom.com. Thank you.